Hi, I'm going to talk to you about a case that is pending before the district court right now in DC that's gotten a lot of attention over the weekend. This is the case that involved, for starters, 5 plaintiffs who were challenging the president's invocation of the Alien Enemies Act. That's a statute that is an 18th century statute. And don't worry, I'm not going to get into the legal weeds. And the president was seeking to remove those people out of the country, allegedly because we're either at war with the country they're from or because they were part of an invasion of this country. There are all sorts of requirements of that statute that didn't appear to be applicable to these people, nor were they given a hearing to establish whether they were or were not people subject to that. Anyway, the upshot is that the district judge had issued an order saying you cannot rely on the presidential proclamation invoking the statute to remove these people. And then he expanded it to say that it applies in general, not just to the 5 people at issue. And there's been a lot of back and forth about whether the judge was right with respect to the Alien Enemies Act, and second, whether the United States government ignored that court order and actually continued to fly people out of the country in spite of the fact that the judge said not to. Again, I'm not actually even going to talk about that, but I will say that there seems to be ships passing in the night because the government's argument is, well, you, Judge, only said we couldn't export and deport these people based on this Alien Enemies Act, but the United States says, well, we weren't exporting them or deporting them under that statute. We were doing it under our inherent constitutional Article 2 authorities, and you never ruled on that. So that's also a separate issue, which is, are they properly invoking the statute, or could they act just pursuant to their constitutional authority? You might be saying, okay, well, Andrew, if you're not going to talk about either of those things, and you're not going to talk about whether they violated the judge's order, what are you going to talk about? And this is what I'm going to talk about. And I'm not going to say it's equally important or more important. It's just an important issue that I think has not gotten attention. I think it's because it's gotten normalized, and I don't want to normalize it. This is the issue, not to bury the lead, which is Pam Bondi, the Attorney General of the United States, after the district judge, a very respected district judge. He is actually the chief judge of the DC District Court, Jeb Boasberg. After he issued his ruling, Attorney General Pam Bondi said the following: tonight, a DC trial judge supported Tren de Aragua, which is that's the Venezuelan gang at issue, the TDA. So tonight, a DC trial judge supported TDA terrorists over the safety of Americans, unquote. So a judge ruling that a statute does not address this issue and cannot be validly invoked by the president, that is, according to the Attorney General, supporting a gang, a terrorist gang, over the safety of Americans. That's the Attorney General of the United States. Here's 2 problems with that. One, a judge saying what the law is and whether you as the United States government are complying with that law is not supporting one side or the other. It is just ruling on legal issues about whether the government has properly invoked the legal ability to do something. If you don't have the legal ability to do it, you don't have the legal ability to do it. It's not saying, oh, you support the cause of one side or the other. Jeb Boasberg is no more saying that he believes in gang violence than Pam Bondi is. Under Pam Bondi's reasoning, excuse me, you could just say any judge who gives trial rights to a defendant is supporting a defendant. Or if you have sentencing rights for somebody who's facing the death penalty, and you're a judge and you're making rulings about what evidence can come in and what evidence can't come in. If you rule against the government, you're suddenly in favor of the defendant's killings. The thing that's remarkable is this is the Attorney General of the United States saying this about a judge. It's fine to say, as she does say later, that she disagrees with the ruling and they're going to appeal the ruling, and that she thinks it's wrong. That's fine. That's fair game. But to say that he's siding with terrorists is really over the line, and it's very, very concerning when you have somebody who is the Attorney General of the United States. Second, she calls the group, the TDA, and the people at issue terrorists. Just remember, there's been no hearing. There's been no adjudicated determination of that. All you have is the allegations of what the government is saying. Heretofore, when you bring a criminal case, and this isn't even a criminal case, when you bring a criminal case, what the department requires when you announce those charges is you have a statement. If you look back at all of the press releases from the Department of Justice, they say these are mere allegations. Even an indictment is just a mere allegation. Why? Because it's untested. It hasn't been proved. Pam Bondi and Todd Blanche and Emile Beauvais, as three personal lawyers for Donald Trump, are amply aware of it, not just because they're lawyers, not just because they're prosecutors, but because they've represented Donald Trump, and they're all too well aware that when Donald Trump was accused of things, he's entitled and was entitled to the presumption of innocence unless and until a jury comes back and determines that he's guilty. And they should be the first people to be thinking about defense rights. They should be the first people to understand that hearings are important, that you can challenge evidence. Just because the government says something doesn't mean it's true. Donald Trump says that to this day, that he was the victim of a witch hunt, that he disagrees with the government charges. Obviously, as a defendant, he's entitled to say that. But he doesn't accord those same rights and that same ability to the people who he just deported. And what's so concerning is that Pam Bondi is recapitulating that language, but she has a different role now. She is not a personal attorney to Donald Trump. She is our attorney paid by taxpayers, and she should not be doing any of those things. It's totally fine for her to say that she disagrees with the decision, but this is so anathema and such another sign that this is a transactional presidency, a transactional Department of Justice, and they're not thinking about this in terms of the principle involved, which is that everyone is entitled to the rule of law. Defendants are clearly entitled to the rule of law. When we have criminal trials, let's just take the criminal trial in New York of Donald Trump. Is it fair to say that Judge Merchan was siding with Donald Trump because he accorded him due process of law, because he didn't do what the Queen and Alice in Wonderland did, which is to say, off with their heads, trial to follow? That the defense rights, the rights that we all have in the Constitution, are given to everybody, and it helps adjudicate whether that person in fact did the crime alleged or didn't do it, or is the person who is alleged. So here's one way to think about this, which I think is useful when I talk to my law students. I think that let's assume that the people who were all deported, let's assume that they were part of a gang. That shouldn't make it any more or less the case that they're entitled to due process. And so it's sort of largely irrelevant, but let's assume that 10 people are deported, and one of them, it was a mistake, that in fact they are not part of the gang at all. Under what the government just did, what process is given to that person to be able to have a hearing to say, you got the wrong person? In the same way that a defendant, just like Donald Trump was until he was reelected as president, was entitled to say, I'm not guilty. I didn't do it. But the process that was done here is one that didn't give any of those people an opportunity to say, you made a mistake. I am not part of that gang. And so you really, Pam Bondi should not be saying to the public that the judge, he shouldn't be saying these are terrorists at this point as opposed to alleged terrorists, and shouldn't be saying that the judge is supporting terrorism just because he says a statute does not apply here. And there's a substantial reason for the judge's argument, but even Pam Bondi, I think, would say, at the very least, reasonable minds could differ. She might think the statute was properly invoked, but you could hardly say that Judge Boasberg had made a decision that's completely ungrounded and untethered to facts and law. And so her language really continues to breed this kind of contempt for law. And finally, it's so political because it serves to undermine judges. It tends to undermine the judiciary, which is not something that you should be doing at the Department of Justice. And it tends to sort of pit the judiciary as being sort of pro-criminal and the Department of Justice being sort of, against crimes and against gangs. And that's just a false dichotomy. That is not what is going on. And that kind of language shouldn't be used within the Department of Justice, where what you're supposed to be thinking about is the rule of law. So I wanted to focus on this and raise it with you because it's an important piece that I think, well, as I said, there's lots of legal issues that we're going to be seeing in the days to come. This is an issue that may very well get to the Supreme Court. But I wanted to focus on the language that we're hearing from the Attorney General so that it doesn't go unremarked upon and unnoticed and gets normalized. Thanks so much for listening.